Hello everyone, I'm George from Ireland. So this lecture is about the law of privacy. Privacy law is very much an area in development because it's something relatively recent in English law. As you may recall, the Human Rights Act incorporates the European Convention on Human Rights into UK law, and the rights from the ECHR are called convention rights for short. And the Human Rights Act requires public authorities to act in a way which is not incompatible with the convention. These rights are enforceable. They can have indirect horizontal effect. Remember, horizontal effect is an individual or legal person being able to enforce them against another individual or legal person, whereas vertical effect is enforcing them against the state. So there are a number of factors in play, and we have to find some sort of equilibrium between the freedom of the media and privacy. So that's a delicate balance. What's the golden mean here? There are different views on this, and the court has to work this out. And different member states have a margin of appreciation, would set the boundaries in different ways. Because remember, although the United Kingdom is outside the European Union, the Human Rights Act is still on the statute book. Some people talk of repealing it, repealing all of it, repealing bits of it. But even if it were gone, then some of the provisions of the convention were already in UK law for decades or even centuries. Anyway, so let's look into some of the background of the law of privacy. So prior to this, there was no right as such to a law of privacy. This was found in Malone and the MPC in 1979, or indeed Wainwright and the Home Office in 2004. No privacy right per se. How about a breach of confidence, as in you had some confidential information? Coco and A.N. Clark, 1969, or the Attorney General and Jonathan Cape in 1976. That was a different matter. I know there's sort of professional issues about confidentiality, but that wasn't a law. For example, I remember John Gross, the celebrated theatre reviewer, his father was a doctor, and Gross said one day we're driving around the car, we saw a poster of a prominent local businessman, and the father blurted out, "Oh, he's monoorchic," meaning he's only got one testicle. And the father thought, "Oh, me and my big mouth." He said, "I could be struck off for this as a doctor, having breached confidentiality and told you he's only got one testicle. That could be the end of his medical career, but it wouldn't have been a crime." Okay, there was they say the Official Secrets Act passed shortly before the First World War about military secrets or espionage and so on, and breaching that kind of confidentiality. Yes, that was a crime, but that was only because you specifically signed up to it. You signed the Official Secrets Act, which is still in force. But for you or me, Joe Bloggs, there was no such right to privacy. Okay, so banks and so on try to keep things secret, but it wasn't a crime if they disclosed things either negligently or deliberately. So let's look at what the traditional remedy was for a breach of confidence. Coco and A.N. Clark in 1969. They looked into the quality of that confidence. How confidential was it? Absolute, partial, or rather lax? And what aspect of the information had to be kept secret? They would ask whether there was an obligation of confidence, as in keeping it private, or was it something which was sort of a privilege, doing it as a favour, keeping it confidential, or not. Not a favour, obligation, you had to keep it that way, and see if the use of some material was unauthorised, or indeed was it authorised. And it was on the basis of those decisions, the court, those pieces of information, the court would render its decision. So the Human Rights Act 1998, which was almost revolutionary in English law, looked at the standard application of privacy. So remember, there's a duty incumbent upon public authorities, courts, the police, the armed forces, schools, the NHS, anything which has some state power is an emanation of the state, local authorities, anything which is state-owned or semi-state-owned, the NHS to act in this way. State schools, and on and on. The diplomatic service, anything to do with the civil service, prisons. So they have to act compatibly with the ECHR rights, Section 6.1, insofar as possible. And public authority, that's the state, and then under Article 34, the victim of some breach of confidentiality, this right here would be vertically applicable. So let's look into indirect horizontal effect as provided for by the Human Rights Act section 6.3a. Courts and tribunals are, of course, public authorities. They're an emanation of the state. They have legal power beyond what an ordinary organization would have, what a charity or a business would have. So the courts have to act consonant with the convention, as stated in section 6.1 of the Human Rights Act. So let's look at Douglas and Hello #1. This is 2001, where Kirk Douglas, the Hollywood actor, he married, oh goodness, I can't even remember her name again, Catherine Zeta-Jones, the one who's in The Darling Buds of May. Don't know what she's been in since. But anyway, so it was actually Jeremy Thorpe's son was the photographer at their wedding. But I can't remember how the OK magazine got a photographer and snapped some photos of them and then published them in a way that the couple didn't want. So they said this was a breach of their privacy. Now, hundreds of guests were there. Was it a breach of your privacy? Or were you just annoyed because you'd sell the rights to somebody else? And I don't know if that breached their contract with with Thorpe. So Keene was the Lord Justice at the time. He said, the courts, as a public authority, cannot act in a way which is incompatible with the convention right. That arguably includes their activity in interpreting and developing the common law, even where no public authority is party to the litigation. So the litigation, as in taking legal action, trying to sue people, maybe negotiate, not be sued, some sort of out-of-court settlement. I'll pay you this, I'll do whatever it is, and you'll sign this, you're dropping all legal action against me. Anyway, it was judged to be tolerable that their rights to privacy hadn't been breached. So let's look at Campbell against MGN, 2004. Naomi Campbell, the supermodel. So this was a tort called misuse of private information. Now, Miss Campbell was struggling with some addiction, I think it was to drugs, and she was going to some support group to help her wean herself off this problem. It was a responsible thing to do. But Lord Nichols said in the case, this cause of action has now firmly shaken off the limiting constraint of the need for an initial confidential relationship. So there wasn't a sort of confidential relationship that was being breached. The newspapers and the photographer, they're quite entitled to go and take a photo coming in and out of this meeting. They hadn't promised not to. She's got no relationship with them. Some sort of professional confidential relationship, no. But they were publishing something that she found a little bit embarrassing. But actually, they got their knuckles rapped, the publication, perhaps surprisingly. So a new methodology has emerged. So there are various parts of this. Firstly, the private law provides a cause of action, okay? And then you have to hang your human rights arguments on these ones, like breach of confidentiality. Or a tortious release of this private information. Second of all, was there a reasonable expectation to privacy? And it was held at a wedding with hundreds of guests. It's not. Or indeed, and you are very public figures. Although oddly, in the case of Naomi Campbell, she's going to this meeting that wasn't exactly secret, and there were other people there, she had a reasonable expectation of that. Okay, it was something akin to medical treatment. Or third of all, parallel analysis. You look at Articles 8 and Articles 10 and you try to find this Aristotelian mean to allow the media sufficient scope and yet not to unduly infringe on the privacy of individuals, including public figures. So we have to ask what a reasonable expectation of privacy is. There was von Hanover and Germany in 2005. So this aristocratic lady, and this is what was decided in the court case when Life magazine published something. Well, it was really about Caroline of Monaco, but I think she married von Hanover. Is that she changed her surname? Anyway, it said that the concept of private life extends to aspects relating to a person's identity, such as a person's name or picture. Article 8 of the Convention is primarily intended to ensure the development without outside interference of the personality of each individual in his relations with other human beings. There is therefore a zone of interaction of a person with others, even in a public context, which may fall in the scope of private life. So even public figures, people who choose to make a fortune as an actress or something like that, they have a right to private life. However, the extent of their private life is more restricted than it is for a nobody like me. Okay, Murray and Express. This is a 2008 case. And Sir Anthony Clark was the master of the rolls, remember, head of the civil division as a judge, and this is what he had to say about it. The question of whether there's a reasonable expectation of privacy is a broad one, which takes into account all the circumstances of the case. They include the attributes of the claimant, the nature of the activity in which the claimant was engaged, the place at which it was happening, the nature and purpose of the intrusion, the absence of consent, and whether it was known or could be inferred that the effect on the claimant and the circumstances in which the purposes for which the information came into the hands of the publisher. That's the end of the quotation. So where were you? On the street? Hard to be private there. On a beach like Anna Ford? Well, that's not private. And what were you doing? Is it something you would really want to keep private, like going to something like Alcoholics Anonymous? Okay. Or engaging like Sir Nicholas Mosley in some orgy with hookers, probably want to keep that private. And he won his case when people exposed what he was doing. He was the head of Formula One, so kind of a public figure. And the claimant, by the way, is the person who moves the action, who claims that his or her privacy has been breached. If you gave permission for whatever media outlet to report this, photograph it, well then, you've got no case, because you just agreed to it, even if you subsequently change your mind. And how did they get this? Did they get this through subterfuge? Now, if you get it through trickery as the media, that might still be acceptable. It depends. It weakens your case a bit, but it depends. Are you publishing it to inform the public of something which is useful to know? Something to do with morality or something which is politically relevant, in which case you might have a quite strong case. If it's something to do with like titillate public curiosity, probably not, because they often come up with fairly spurious reasons about this. Cherie Blair claimed her privacy was breached over something like that or something or other. She lost a case partly because, like in her autobiography, she said about failing to take contraceptive equipment to Balmoral in August 1999, which is why her child Leah was conceived. And one of the arguments was, you breached your own privacy by telling us all this. Okay, so we'll look at the parallel analysis. Article 8 is about privacy rights, but Article 10 of the European Convention of Human Rights is about freedom of expression, including of the media, not just me, say and what I like, hear, paint a picture, take a photo, that kind of thing, wear what I like. That's all freedom of expression. Perform a play, sing a song. This is all freedom of expression. So we'll look at the Campbell result to do with Naomi Campbell. It was held that there are certain justifiable intrusions on a person's privacy. Now, she was a public figure, she's a role model, she's a model, and she's addicted to illegal substances. So isn't it good that the public know this? It's important to realise perhaps she's not such an ideal role model, or there's a downside to being a model, and that she's receiving treatment. That's what they said, well, that we justified to be telling the public that. But what was unjustifiable about reporting it was the fact that her treatment was at Narcotics Anonymous, this group of people who wanted to stay private. And also they released the particulars of her treatment, and there were photos of her at the Narcotics Anonymous clinic. Okay, so Article 10 and Article 8 are in creative tension. So Section 12.4 of the Human Rights Act says that a court must have particular regard to the importance of the Convention right to freedom of expression, which would include taking photos and publishing the said photos. However, Article 8 and Article 10, well, neither of them is given priority. You have to find some sort of balance. It's quite tricky for judges. So here are some factors which they quite often take into account. How was the information got? Did they obtain it through underhand means? Well, Ashworth Security Hospital and MGN 2002 was a case about this, or His Royal Highness the Prince of Wales and Associated Newspapers 2006 about them breaching his confidentiality. Do you court publicity or do you shun publicity? Well, Naomi Campbell lives by it because she's a model, so she courts it. McKenna and Ash 2006, or Murray and Big Pictures, are also about people and their relationship with the media in general, not just that medium of communication, or not just that publication, was also pertinent to the bench's ruling. Are they role models in A and against B and C 2002, or are they third parties, not public figures? Is there sufficient public interest in the story or information? Now, by public interest, they do not mean what the public is inquisitive about. Public interest means like public advantage or public benefit. Does it benefit the public to know this? To know about the private life of a politician if he or she is being hypocritical or criminal or something like that? And they would say, yes, it does. But to know about their private sexual activities, probably not. There was Mosley and the News Group, 2003, when the judge here was Justice Eadie. And so the News Group lost this. His supposedly Nazi-themed orgies, the Formula One boss, son of Sir Oswald Mosley, who was leader of the British Union of Fascists. So they secretly filmed his sex parties without his knowledge and then published it, but they lost their case. Mosley won, and people said that's the most chilling effect on investigative journalism. But the newspaper, was it really trying to tell us something which was relevant to the public? Perhaps it wasn't germane to public debate. It was just because they thought it was a salacious story. It would sell more of their rag, because people love a good hate, they love a scandal. Ooh, isn't he naughty? And they're just appealing to prurience. So they say any claim that there was some public interest in this is bogus. Right, that's just a little bit about the law of privacy. Media law really is scintillating. One of my favourite things, that and defamation or libel and slander. So please follow me on Twitter and Instagram and Facebook. See my other channel, George from Ireland, and indeed my channel, British Poesy. So book online law lessons with me, and lessons in all sorts of subjects like history, politics, religious studies, English literature, English language, and French. And I can be your tour guide in London. And let me see what else. I translate from various languages, from French, Spanish, Italian, Romanian, Russian, and German, particularly legal documents. Toodaloo.